Special contracts. Unity contract. Case laws with examples and elaborated explanations. Adamson v. Jarvis, 1827. Facts. An auctioneer sold goods on behalf of a principal who had no authority to sell, leading to a lawsuit against the auctioneer by the true owner. The principal promised to indemnify the auctioneer for in. The court held that the auctioneer could recover losses from the principal under the indemnity contract, as the loss arose from the principal's actions. Explanation. This case illustrates that an indemnity contract activates when loss occurs due to the indemnifier's conduct or instructions, emphasizing the primary liability of the indemnifier. It underscores Section 124's application where the indemnifier compensates for direct consequences of their actions. Guild v. Conrad, 1894. Facts. A guarantee was provided without proper documentation, and the creditor sought to enforce it against the surety. Decision. The court ruled that a contract of guarantee must be evidenced in writing to be enforceable, distinguishing it from indemnity, which can be implied or oral. Explanation. This highlights a procedural distinction. Guarantees require formalities due to their tripartite nature and secondary liability, aligning with Section 126's requirement of a clear promise. Unlike indemnity, the involvement of a third party, debtor, necessitates clarity in the surety's commitment. Kalashnath v. State of UP, 1968. Facts. A contractor faced losses due to government actions and claimed indemnity based on an implied contract arising from the circumstances. Decision. The Indian court recognized an implied contract of indemnity, allowing recovery of losses. Explanation. This case demonstrates that indemnity can extend beyond express agreements, focusing on loss compensation. It contrasts with guarantee, where the surety's role is explicitly tied to a debtor's default, not an independent loss event, reinforcing the bilateral versus tripartite distinction. Bank of Bihar Limited v. Damodar Prasad, 1969. Facts. A bank, as creditor, sued both the principal debtor and surety for a loan default. The surety argued limited liability. Decision. The Supreme Court held that the surety's liability is coextensive with the debtor's under Section 128, unless restricted by the contract. Explanation. This case exemplifies the secondary nature of a surety's liability in a guarantee, activated only upon default, unlike indemnity where liability is immediate and primary. It clarifies how guarantee operates as a security mechanism rather than a direct loss cover. Conclusion. Contracts of indemnity and guarantee, though sharing the common goal of risk mitigation, diverge in their legal frameworks and practical applications. Indemnity's focus on direct loss compensation between two parties contrasts with guarantee's role as a contingent security involving three parties. These distinctions, rooted in Sections 124 and 126, are critical for determining contractual obligations and liabilities. Mastery of these concepts ensures effective navigation of legal disputes and commercial arrangements, making them indispensable in contract law studies. Memory aids. Table: Indemnity versus Guarantee. Feature: Indemnity. Guarantee. Parties: 2. 3. Liability. Primary. Secondary. Purpose: Loss compensation. Debt security. Contracts. 1. 3. Implied. Mnemonic: Indemnity is instant, guarantee grows gradually. 2 GGG highlights immediate liability in indemnity versus gradual, contingent, liability in guarantee. Mind map: Center, contracts, branches to, indemnity, sub-branches, 2 parties, primary liability, and, guarantee, sub-branches, 3 parties, secondary liability. Rhyme: Indemnities 2, loss is the cue, guarantees 3, default sets me free. Keywords: indemnity, guarantee, primary, secondary, loss, default. Q2 Q15, define contract of guarantee. Explain the rights of surety, explain the rights of surety. Synopsis. This answer defines a contract of guarantee and provides an exhaustive explanation of the surety's rights against the principal debtor, creditor, and co-sureties, ensuring a comprehensive response for maximum marks. Introduction. A contract of guarantee, as a cornerstone of the Indian Contract Act, 1000. Introduction. A contract of guarantee, as a cornerstone of the Indian Contract Act, 1872, facilitates trust in transactions by involving a surety who undertakes to fulfill a debtor's obligation upon default. The surety's role, while secondary, comes with significant rights to protect their interests against the principal debtor, creditor, and co-sureties. These rights, enshrined in the Act, balance the surety's obligations with remedies, making them a critical study area in contract law. Description explanation. Definition of contract of guarantee. Under Section 126, a contract of guarantee is a promise by the surety to perform the principal debtor's obligation or discharge their liability to the creditor if the debtor defaults. It involves three parties: the surety, guarantor, the principal debtor, whose obligation is guaranteed, and the creditor, who benefits from the guarantee. The contract is contingent, with the surety's liability arising only upon the debtor's failure. Rights of surety. The surety enjoys rights in three distinct relationships. Against the principal debtor. Right to indemnity. Section 145. Upon paying the creditor, the surety can claim reimbursement from the debtor for all payments rightfully made. This implied right ensures the surety is not out of pocket for fulfilling the debtor's obligation. Right of subrogation. After payment, the surety steps into the debtor's shoes, inheriting all remedies the debtor had against third parties related to the debt. Against the creditor. Right to securities. Section 141. The surety is entitled to the benefit of any securities the creditor holds from the debtor, whether obtained before or after the guarantee, upon discharging the debt. Right to set off. The surety can use any set-off or counterclaim the debtor could have raised against the creditor. Against co-sureties. Right to contribution. Section 104.